Now, this is arguably, I think, been the most disastrous week for Israel in terms of its quote unquote international standing since its foundation. We've had the International Criminal Court chief prosecutor issue requests for arrest warrants against its leadership. We've had 3 European nations on top of those who've already done so, recognizing the state of Palestine. And we now have the International Court of Justice issuing provisional orders, more orders, demanding Israel ceases actions, military actions in Rafah, as well as unimpeded UN fact-finding missions, and to open the Rafah crossing, which is obviously crucial for humanitarian aid. Now, I really want to talk about the significance of what the ICJ in particular means. We're going to talk about the ICC and other stuff as well, but I'm really delighted to be joined by Heidi Matthews, Assistant Professor of Law at Osgood Hall Law School, York University, specializes in law of war and particularly looking at questions of genocide. I've been following Heidi's work all the way through this horror, and you've been a lifeline for so many of us. So thank you, Heidi, for your brilliant work, and it's an honor for you to talk to you.
Well, it's so kind. Lovely to be here.
Well, I just want your first general take in the International Court of Justice ruling.
Yeah, so this has just been with us for a few hours. So those of us in the nerdy International Court of Justice universe are kind of sitting with it, reading the majority opinion, but notably some appended declarations by the judges. We could talk about that as well, because it's part of the Israeli government's spin on what this order actually constitutes. So I'll give the kind of simple version, which I think is very difficult to upend, of what the court said. But the basic reading here is that the court made the factual finding that Israel's attempts or efforts, Israel itself called these extraordinary efforts, at ensuring both adequate provision of humanitarian aid and assistance, so that would be, food, medicine, water, fuel, all of that, shelter, etc., to the population, as well as efforts to minimize civilian harm in the context of Rafah. The court sided with South Africa very, very clearly, saying we don't accept the contention by Israel that it's taken these extraordinary measures, or really any measures that would be sufficient to satisfy its obligations under international law. And so the reason why I started with the factual finding there, as opposed to starting from what was actually ordered and then working backwards to the facts, is that the factual findings that the court made, so rejecting Israel's contentions and accepting very clearly those of South Africa with respect to this question, is that it helps us make sense of what the order actually is, because there is some spin swirling around the order right now. So for folks who are into this kind of thing, you can find this online, but the first order, and I'll just read it and I'll let you know where the punctuation is, because this has become an issue. So the first, or the most important part of this order from a ceasefire perspective, is as follows. Israel is ordered to, quote, immediately halt its military offensive, comma, and any other action in the Rafah government, comma, which may inflict on the Palestinian population, group in Gaza, conditions of life that could bring about its physical destruction in whole or in part. So to my mind, in light of the factual determination that I started with, this is a very clear order from the court to the Israeli government that it must immediately halt any military activities within Rafah.
Yeah. But so I'm going to go on because I was going to put the spin, the Israel Foreign Ministry spin.
You give the spin.
So they come out with their joint statement with the head of the National Security Council, the spokesperson of the Ministry of Foreign Affairs. South Africa's really mean. Charges of genocide, false, outrageous, and morally repugnant. War of self-defense. We're trying to get our hostages back. Obviously, they've killed more than hostages than they've rescued by military means. Israel has not and will not conduct military actions in the Rafah area, which may inflict on the Palestinian civilian population in Gaza conditions of life that could bring about its physical destruction in whole or part. So they're like, okay, yeah, fine, we're doing that anyway.
Yeah, exactly.
And that doesn't accord, though, does it, with the fact, because all the way through the ruling, the court makes clear things were terrible in January, but things have got a lot worse, and there's a humanitarian catastrophe. So the whole point of what they're saying is this is a catastrophe now in Gaza.
Yeah, exactly. So, and the court is at pains to kind of walk us, like in the 18-page majority order itself, is at pains to walk through the progression of the deterioration of the humanitarian situation in Gaza in general, and also with respect to Rafah in particular. And so it talks about the order it made in January, about how it reaffirmed the order, and then modified it twice, most recently at the end of March. It noted very clearly that its worry at the end of March that the situation was about to deteriorate even more has come to fruition, basically. So the risk of deterioration that the court was concerned about has intensified, and it's significant change in circumstances that justifies ordering these new measures. And so the idea that either Israel is permitted to carry out military activities if they don't have a genocidal impact, or, as one of the judges appears to be suggesting, Israel's permitted to carry out defensive but not offensive activities, as though that were an operative distinction in terms of the law of war. Neither of those interpretations, to my mind, make any sense with respect to the factual findings that the court has clearly made.
And it's clear. I mean, when we're talking, just in terms of what they're actually talking about here, they're saying that could bring about the physical destruction of the Palestinian group in Gaza, conditions that would bring about its physical destruction in whole or in part. That's genocide. That's just short. That's the definition of genocide.
It's part of the definition of genocide. So if you look at Article 2 of the Genocide Convention, there are 5 different ways, different kinds of acts that can constitute genocide, and causing conditions of life that could bring about the physical, or that are intended to bring about the physical destruction in whole or in part of a group, constitute a genocidal act. And that's actually really, I'm glad you mentioned that, because it's an important specification. I had inferred from previous court orders, including the one in late March, that the specific genocidal act that the court was concerned with, more concerned with than others, was this sub-act. In other words, causing conditions of life calculated to bring about physical destruction in whole or in part, as opposed to, for example, killing members of the group. Obviously, that's happening too, but it's been apparent in each of the court's orders that actually what it's really concerned with is this kind of system-wide, population-wide humanitarian catastrophe, which now the court in this order comes out clearly and says has now devolved into something worse. It says it's a disaster.
I mean that, in terms of talking about it being a disaster, must surely mean, because it's not spelled out in those terms, that Israel has failed to abide by the specific orders issued by the court, which are orders, whatever the former president of the ICJ, the kind of semantic war she unleashed in a interview with the BBC, I believe, is because these orders were in order to protect the Palestinian people, a protected group, from physical destruction in whole or part, as in genocide. And one of those is critical, is unimpeded access to humanitarian aid in order to satisfy the needs of life. Now, they've clearly refused to do that, and obviously the overwhelming evidence being what it is, but also that's a key plank of the International Criminal Court's prosecutors' request for arrest warrants for Netanyahu and Defense Minister Yoav Gallant, isn't it? So that's the point. To get what they're saying is, because they had to issue that order in January, then additional order in March, because they clearly hadn't done so, and now they're saying things are disastrous. So they must be saying you are failing to satisfy you are flouting our orders, and these are orders to prevent genocide.
Yeah. Absolutely. You'll see my head turning here just because I have another screen where I look for like precise language. But yeah, so the court says this, and I'm quoting now from today's order. The court is not convinced that the evacuation efforts and related measures that Israel affirms to have undertaken to enhance the security of civilians, in particular those recently displaced from Rafah, are sufficient to alleviate the immense risk, and that risk is the risk of genocide, namely, but not limited to, having conditions of life inflicted to bring about physical destruction in whole or in part.
So some might now look at this and go, well,
yeah,
what does it all really mean? I mean, in fact, it's quite interesting, actually, because Judge Dyer Tladi, who's from, just to be clear, which nation again? I can't remember now.
I think he's a South African judge.
Yes, he is. He is South African. You're absolutely right. Yeah, and he says with no words to describe the horrors and Gaza, the words apocalyptic, exceptionally grave, disastrous, and catastrophic. He's saying they don't even do it justice, basically. Yeah, I mean, so he talks about all of that, but he says at the end of the day, he said this is just a court. I mean, and he does make that clear. He said they were basically saying there were limits to. And that Israel can, Israel just goes, well, they've got the ICC now, they've got the ICJ, they've got various European nations. Clearly, they're becoming increasingly isolated, but they're still carrying on. So what does it all mean?
Yeah. Well, I'll do my best. Yeah, I mean, I think, I've resisted using language that says, this is a big test for international law, because it seems that every prominent or important case gets touted as a test for international law. And, and if we don't see, an immediate and sort of satisfactory resolution, then international law has failed and, isn't alive or an operative kind of factor in geopolitical operations. And I think that's a little bit too simplistic. That being said, this is a test in the specific sense for Biden, but others, particularly states who are members of the International Criminal Court, which we'll talk about as well. And so I think from the perspective of this judgment, Biden and his administration have been kind of clear that they were opposed to what they called a large-scale operation in Rafah, and they've resisted, basically using Israeli talking points, that what is happening in Rafah constitutes a large-scale operation. They say it's limited and targeted and, done in a way that provides maximal protection for civilians, et cetera. And of course, that's not true. And so what we see, again, the importance of the factual finding here, in addition to the order itself, is that the court has found that Israel's claim that this is not a large-scale offensive with the kinds of humanitarian impacts that a large-scale offensive has on the population is implausible. So we haven't seen, I don't think yet, unless you've seen something that I haven't, a response from the U.S. yet.
No.
Here.
No, not as we speak.
Yeah, it's coming, I guess. So we can all look forward to, Matt Miller or whoever trying to do this language game too. But it'll be interesting to actually see how they choose to do this. But, some kind of spin is coming. The real point, though, is that, as I've said, the court has found that this humanitarian situation is a result, effectively, of a large-scale operation. And even if it weren't a large-scale military operation using some kind of, other, definition of what a military offensive means, the humanitarian impact is such that it cannot continue, right? Because we're at disaster level. And I think the other factual finding that I haven't seen others talk about here, but I think is really important, is the role of the forced displacement, right? So the court finds that over 800,000 people having been forcibly displaced from Rafah under the guise of evacuation orders to parts of Gaza that are not fit for human habitation, essentially, that in and of itself constitutes a humanitarian disaster. And that's before the offensive even starts, right? We're not even in that zone. The forced displacement is enough to get to that point, I think. And
Before
so
I ask,
what that
yeah, go
means,
on.
just really quickly, so what that means for Biden is, okay, so the court has found that we are in fact in a large scale offensive. There is in fact a humanitarian disaster. Is Biden going to admit that that's what's happening, or will he continue to spin it as not what's happening? And we might see, I think we will likely see some kind of resolution at the Security Council in terms of enforcing this order, and then the U.S. has a choice to make.
Before I ask just how this fits together, the ICC, the International Criminal Court. We mentioned there briefly in terms of judges sometimes set out their own thoughts separately, don't they? They set up their, and some of them have. I just wonder your general thoughts on what that tells us, what the judges have said.
Yeah, I'm not entirely sure what's going on here either. So what the order of this would have been if the judges received the majority opinion. So the judges who wrote separate declarations, who agreed with the majority order, but are interpreting what the impact of that order means differently. In other words, interpreting it not to mean an actual end to hostilities in Rafah, but just an end to like the hostilities that cause the risk of genocide, right? There are a few judges who've taken that position. There's a question about whether they have taken that position sort of in a quite what would be, I think, a very cynical manner, which is to say they looked at the majority opinion, they looked at the way that the order was drafted, which admittedly could have been clearer from a grammatical perspective, and they thought, okay, we can agree to this using our interpretation, which is more restrictive than the one that the majority is advancing. That is unfortunate because again, that the fact that the judges have actually come out and said, we only think I don't know how you'd even describe it. We're in favor of a non-humanitarian disaster offensive. In circumstances where we know a humanitarian disaster is already underway. But that's what they've said, essentially.
Actually, I kind of think it's odd that all the judges don't just issue their own declarations. It just seems a bit lazy, if anything. It seems a bit like, oh, I've put in a vote. I'm done now. I don't really have time. I've got other cases.
But it gives us certainty. The problem is when you've got everybody weighing in on what they understood the Oxford comma to mean, then we're in trouble, right?
Yeah. That makes sense. So putting this together now, with the International Criminal Court chief prosecutor issuing these arrest warrants requests, so this is very important, requests for arrest warrants this week. Though it has to be said, I mean, by Kenneth Roth, the former head of Human Rights Watch, says this is someone with a very conservative approach. His special advisor says the evidence is absolutely overwhelming. They're extremely confident these arrest warrants will be issued. I mean, is this the week Israeli impunity really just collapsed?
One would have thought, and again, this is where we're in this like zone of a political test for the core institutions of international law in the post-World War II United Nations era, frankly, because what we have seen in response to Karim Khan's going public on Monday that he has requested these warrants, what we've seen, not just on the part of the U.S. and Israel, which we would have expected a very strident response. The U.S. has a complicated relationship with the ICC. When it prosecutions there serve its purposes, such as in the Ukraine-Russia case, with warrants against Putin, they have no problem. They're very supportive, but overall have been at times extremely hostile to the court, and of course are not a state member of the court. Neither is Israel. So we would have expected, I think, the kind of really strident frontal assault, essentially, that the U.S. and Israel have come out with. What was more surprising and worrying to me, watching all of this unfold this week, is the way in which other Western liberal democratic allies, primarily English speaking, but not only, of Israel, have taken the same stance. So countries that are not only members of the International Criminal Court, but have been historically extremely important members of the court from the perspective of providing funding, personnel, negotiating the statute, populating, the court, etc. So all kinds of both political material and intellectual support for like the project of this court over the last 25 years. Those states have also come out and basically repeated the script that somebody in Washington or Israel has come up with, which is to say, uh, uh, charging these three Hamas leaders with Netanyahu and Gallant constitutes a form of false moral equivalency.
Mm-hmm.
So there's literally a paragraph that, like, I don't know, every senator and congressperson in a sort of bipartisan fashion, as well as officials from all of these other states, Canada, the UK, Germany, um, uh, have just kind of repeated all week long. And that to me raises a lot of questions about the extent to which those states, again, who are important members of the court, are now acting in a way that is at minimum gives the impression of a lack of cooperation, which is a legal obligation on those states who are members of the court.
I do wonder, I mean, how far do you think the net could end up being cast? Because obviously we've got the moment. I mean, I wonder if you think partly this kind of, because the international order has been so rigged in favor of the global north, this is symptomatic of the global north's decline and the global south flexing itself. But Israel is still protected by, it's got the you got the hegemon on side. That helps. That's where they're currently at. But how? Because obviously if we look at other, like in former Yugoslavia, you didn't just put on Slobodan Milosevic. You didn't just hold them legally accountable. And I don't just, the Genocide Convention obviously was set up because of and in the aftermath of the Holocaust. And the argument then was, I was just following orders doesn't cut it. You can't get away with that. And I'm just, at the moment, we've got Yoav Gallant and Benjamin Netanyahu in the frame. But I mean, you can't just argue they're the fall guys. Legally, could this end up? I mean, what of the question at the moment of arms sales to Israel by states, which now we've got the ICC and the ICJ. Doesn't that put a lot of people in quite a lot of legal jeopardy in theory?
Yeah. So a bunch going on there, but I'll start backwards. So the question of arms sales. Yeah. So states who are engaged in significant military trade with Israel and also assistance of other kinds. So, the US being obviously at the top there, but also Germany following next, and then the UK, and then some other states that, it's not a massive amount of assistance, but Canada, my own state of nationality provides assistance as well. And all of these states are bound by an international legal framework around the arms trade. That they have enacted within their own domestic law. And so in the US, you'll hear things like about the Leahy Law. Germany has its own regime that it detailed at the ICJ, etc. There's a legislative regime in each country that's set up to do this. And the basic idea is that states are not permitted to authorize arms exports when there is a substantial or serious risk that the destination country will use those arms to commit serious violations of international law, war crimes, crimes against humanity, genocide, etc. So, way back now in January of this year, with the first order from the International Court of Justice, which did find that there was at minimum a substantial risk that genocide would occur in Gaza. At that point, all of these states were on legal notice that they were selling arms in a situation where there was a substantial risk at minimum, if not an already ongoing genocide, right? So the duty to seriously look at one's domestic arms trade regime and ask those questions about compliance was, let's just say, heightened domestically by that court. But also there's an international level obligation. So an obligation that's separate from whatever domestic export regime a state has, there's also, of course, an international obligation to prevent or punish genocide. And clearly, part of the obligation to prevent includes not engaging in military trade or assistance where there is a serious risk of violation. So that's been in play for quite some time now.
Yeah.
You know, I'm sure your audience knows about litigation efforts in various countries to try and get a handle on that.
Yeah. We interviewed a solicitor leading some of that particular attempt here in Britain.
Oh, great. Yeah. So your audience will know about, So that's been going on for some time. Whether the ICC move, so the prosecutors move at this point, it doesn't like create a new obligation. I think it just it builds or strengthens the evidentiary foundation for states when they're reviewing the compliance with their domestic laws. So if assuming that these arrest warrants are issued, what that means concretely is that judges at the International Criminal Court have decided that there are reasonable grounds to believe that these accused persons have committed these crimes. And those crimes, the ICJ has given us certain determinations around genocide. The crimes that the ICC have charged don't include genocide, critically. We could talk about that too, but extend to war crimes and crimes against humanity. So now we've got like the whole terrain of international criminality, we could say, is covered essentially. Yeah.
But in the case of the chief prosecutor's arrest warrant requests, there could be other charges, and also there could be secret what they're called, secret arrest warrants. They're not called that. What are they called? What's the legal term for that? Sealed.
They can be sealed. Yeah, exactly. So there are a bunch of different options. Arrest warrants. Look, it's open to the prosecutor once a warrant has been issued to seek to amend the charges, right? Mm-hmm. To add additional warrants, to add additional individuals.
Yeah. Because torture is not there, and people would look at this and think, "Come on, torture! Come on now." There's so much evidence about torture.
So we do have torture. Torture is there for Hamas, I believe.
Yeah. Reasonable, but there's none at all for that massive widespread evidence about torture. I mean, CNN et al. CNN and media organizations like that have reported overwhelming evidence. So anyway, who knows? Yeah.
No, totally. And I think like just quickly, like there's the prosecutor has there's a litany of crimes that could be charged against Israel in these circumstances, and choices have to be made, right? And so the prosecutor is going to be making certain decisions that have to align with expressed priorities of his office, with investigative constraints, resource constraints, all that kind of thing, and also with the overarching theory of the case. And the theory of this case is that Netanyahu and Gallant are involved in a common plan. I'm just going to use the language here from the prosecutor, a common plan to use starvation as a method of war and other acts of violence against the Gazan civilian population as a means to eliminate Hamas, secure the return of hostages, but also to collectively punish the civilian population in Gaza. And so...
but crucially as well, they say who they see as a threat to Israel. I look at that and I think, how could that not be genocidal by definition?
Yeah.
If you think the civilian population poses essentially an existential threat to your nation, that is genocide. That's the basis of genocide.
Yeah, like, well, I mean, it's one way in which we get to genocide quite quickly, right? There's a number of reasons for which you could commit genocide, but I think what you're saying is it makes clear one of the contextual elements that is needed for crimes against humanity, and that is a intentional attack that is widespread or systematic, directed against the civilian population itself. And so that's partly how the prosecutor gets there.
That's the other thing I wanted to talk to you about, and that is about genocide as people understand genocide. Because it strikes me that one of the ways, I suppose, both by Israel itself, or official Israeli spokespeople, ministers, all the rest of it, and their cheerleaders, is they've manipulated people's lack of understanding of genocide, including how common genocide is throughout history. So as a consequence, the Holocaust basically becomes the main reference point for people. It feels, I mean, obviously, the Holocaust was, the Shoah was a particularly heinous genocide, but I suppose in that sense, what we're talking about is the Holocaust is an outlier. It strikes me, because it was an industrialized attempt to exterminate an entire people, which succeeded in killing 2/3 of all European Jews in a very short space of time, and it was against an entirely defenseless civilian population. So, for example, when I argued with Piers Morgan, probably for a punishment for something I did in a past life, last November, and, I pointed out to him, he'd said that Russia's attack on Ukraine was genocide. Mm-hmm. I would question that myself. I think it's a brutal invasion. Anyway, whatever. But who knows? But anyway, he said, because that was because the difference is what Israel did was self-defense. But that's not what. How a genocide starts is neither here nor there. It's either a genocide or it isn't. But what it taps into is people don't understand how common genocide is and how it often emerges during an armed conflict, where you have an armed group supposedly representing or part of an ethnic group, which then the civilians get exterminated. Rwanda is one example, or in Bosnia.
Yeah, no, totally. Yeah, so this has been referred to as and I'll talk a little bit about the Canadian context for a particular reason, but this has been referred to in recent developments here as the Holocaust prototype, right? And so, which is a fundamental misunderstanding of the nature of genocide as it was conceptualized by Raphael Lemkin, who of course came up with this in the 40s, and then how it got institutionalized, which actually looks quite a bit different in the Genocide Convention itself. And then
for people who don't know, he's a Jewish Polish lawyer.
Yeah, totally. Yeah.
Yeah. Sorry.
No. That's super helpful. Thanks. So he had in some senses, a broader understanding of actually what constitutes genocide. Anyway, that works itself out in terms of the treaty. And then that works itself out in terms of inclusion in the Rome Statute, other tribunals in the 90s, and then a series of judicial developments that kind of make meaning of the actual text of the convention itself. And so, a few things that people, if you look at the text of the Genocide Convention itself, and I've alluded to this before, but we don't actually need killing, right? Like, theoretically, you could have, it's difficult, obviously, factually, and would be very rare, but if you're just looking at interpreting the statute itself, you don't actually need killing of individuals, right, in order to bring about the destruction of a group. There is a debate about what the meaning of physical destruction means, and if it can encompass the capacity of a group to actually survive in time as a group, notwithstanding the fact that there may not have been a massive amount of death. So all of that to say that there's this internal debate within the law of genocide around that. But certainly the Holocaust as a prototype is just it's a misleading, it sort of undergirds a bunch of misleading ideas about what the law of genocide means, but also about, as you say, what it means historically. So, this idea, which Israel continues to put forward, that military operations conducted in self-defense, and we can have a debate about whether self-defense applies here. That's for another day, right? But let's assume that Israel's acting in self-defense.
Gaza is technically occupied under international law. Yeah.
Correct. Yeah. And so it's not that, and I want to be clear there, it's not that Israel wouldn't have the right to defend its citizens in some fashion, but it's a question of whether it can resort to the use of actual war to do that, right? Armed conflict. There are other ways you can do that: policing operations, counter-terrorist operations, counterinsurgency operations, et cetera. You don't have to do all-out war. So anyway, let's assume all-out, some military response to the level of armed conflict was actually required. Okay, fine. Once the conduct of that operation starts having genocidal impacts on the civilian population, then the story has changed. So, and this is something that South Africa has been hammering home at the ICJ for months, is that you can't, nothing, not even self-defense, justifies genocidal actions. And so the two are not mutually exclusive by any stretch of the imagination.
Because just on that, I mean, again, all of these are very different. I mean, this is the point, genocide, the way they, their historical context, how they unfold, all very different. But I just think it's striking. Rwanda, you had, the genocide against the Tutsis by the Hutu extremists.
Yeah.
And obviously, you could start the clock in theory and go, well, in 1990, the Rwandan Patriotic Front, who represented the interest, supposedly, of the Tutsi minority, invaded Rwanda from Uganda, committed, I would note, a lot of atrocities, killed a lot of innocent people. They were also accused of, for example, rape. And then Hutu extremists declared this was an attempt at genocide, that they were going to commit genocide against the Hutus. And then up to and during the genocide, the Rwandan Patriotic Front killed huge numbers of people. No one looks at that and go, and well, that's self-defense then. You would never, obviously, that, and I guess, obviously, because there you had people being macheted to death. It was a different, but in this case, it's bombs and starvation. But I mean, that's the point, isn't it? People don't often understand how genocides often play out, where it is a case of atrocities can be committed against the group which represent, or the civilians of a group which then commits genocide. I mean, because Hutus were killed and their rights were violated. But that doesn't, people don't, and it's the same in Bosnia. Bosnian Serb civilians, thousands of Bosnian Serb civilians were killed. Yeah. That doesn't,
And we often talk to you about like the Rwanda case as though it was limited to those 3 months of horrific kind of, expedited murder. Whereas, that armed conflict continues across, a variety of borders.
Democratic Republic of Congo, yeah.
So
and the other point there is incitement really comes in, doesn't it? Because the other point the point I want to make is Israel has been told you have to take criminal action. You have to take action against those who incite genocide, and they've just carried on inciting genocide across. Because this is the point. Sometimes you'll see a figure on national television, and the point is Israel has a responsibility under the Genocide Convention, which it put into its own law, its statute books in 1950. To prosecute those people, and it hasn't done so. It hasn't prosecuted any of these ministers or politicians or media outlets.
Yeah, absolutely. And so this will come up not only with respect to South Africa's genocide case, but also to the ICC arrest warrants. Part of what we're going to see in terms of Israeli objections to both the jurisdiction of the ICC and also the admissibility of this particular case is this argument around something called complementarity. That's a principle that undergirds the ICC institutional system. It just means essentially that the ICC needs to be a court of last resort, primary jurisdiction for prosecuting genocide, but also war crimes and crimes against humanity lies with the domestic system. And we've seen Israel making its case already at the ICJ in this respect, saying, look, we know the difference between hate crime and incitement. We have an excellent Supreme Court, fabulous jurisprudence, Judge Barak. We're able to take care of this ourselves, right? We see Matt Miller, like the other day, saying the same thing. The U.S. position is that Israel's legal system is, very sophisticated. Israel has jurisdiction here. International jurisdiction isn't warranted. But the thing about complementarity is that it only comes into play as a means through which the admissibility of a case at the ICC can be rejected if that state is pursuing charges against the same individuals that have been named and for the same conduct. So in general, we don't see prosecutions either for incitement or other violations of IHL in Israel right now, but we certainly don't see cases against Netanyahu and Galad himself. And Israel so that's the quick. Yeah.
Israel would have to prosecute Benjamin Netanyahu and Yoav Gallant for war crimes and crimes against humanity for that to work as a defense.
Yeah.
Brilliant. Heidi, I think we've gone through so much there. It's been we've a real tour de force. You can see why I've been looking to Heidi's wisdom and knowledge all the way through this. We went to a lot of great granular detail. So do press subscribe and leave your comments. But Heidi, that was great. Thank you so much.
Great. Thanks so much for having me, Owen.